Welcome once again to Lehto's Law. Here's Steve Lehto.
Donald sent me a story, and as soon as I saw the headline, I knew exactly what they're talking about. And you may have heard that if you spend time in prison, for instance, you may sit in a cell all day long. You may go out in the yard once in a while. You may go, eat, and then you may have the opportunity to actually work. They may say there's a license plate factory. That was the old joke. And you might go make license plates just to kill time, and they'll pay you for your work, but they're not going to pay you a good wage. In fact, they're not going to pay you minimum wage. And I've heard stories where people are working in these factories or other prison workshops, and they're doing things like, making, 15 cents an hour, that kind of stuff. And I've spoken to people who spent time in prison, and I've heard about the experiences they had and where they worked and what they did. And the interesting thing is that in some places, they'll actually take these workers from the prison, i.e. prisoners, and actually let them leave the premises and go work someplace for an actual company and still get paid that ridiculously low wage. Well, you're a prisoner. You don't expect to get minimum wage, do you? Well, it turns out that Baltimore County detainees could be employees who are entitled to minimum wage, according to an appeals court there. Leah Russell wrote this along with Madeline O'Neill for the Baltimore Sun. A federal appeals court ruled a couple days ago that Baltimore County jail detainees could be covered by state and federal labor laws, reversing a previous decision that said work program participants were not entitled to earn minimum wage. Three-judge panel, the Fourth Circuit, sent the lawsuit back to a lower court, finding that Baltimore County's main purpose in sending prisoners to work at its recycling plant was saving money, not rehabilitation. And that was always their excuse before is, well, these people are here to be punished, and so if we pay them a full minimum wage, we wouldn't be punishing them. So, we're entitled to pay them less. Today's decision is a historic precedent-setting decision, which is not just a victory for these hardworking workers, but for all U.S. workers whose wages may be impacted by the use of inmate labor, says the attorney representing the detainees in their class action lawsuit. And that's another interesting angle to this, is how it affects the workforce in general. So let's suppose you own a company that is a metal stamping company. You stamp metal. And you make money doing that, but you have to hire people and pay them a minimum wage. Meanwhile, across town is a competitor who does metal stamping, and they get workers from the prison that they can pay way below market wages. They can undercut you on what they sell because it costs them less to make it. And that is an unfair advantage they get from being able to use that low-cost labor. A Baltimore County spokesperson declined to comment on the ongoing litigation, which will now return to U.S. District Court in Baltimore. U.S. District Judge ruled in June that county jail detainees who were detailed to the plant were not covered by the Fair Labor Standards Act, which is the federal law that governs overtime and minimum wage for most U.S. workers. So here we're talking about jail, but I'm not sure that there can actually be a distinction made between jail and prison with respect to what they're entitled to if they're working while there. So an Essex man who was briefly detained at the Baltimore County Detention Center was the lead plaintiff in what is now a class action lawsuit. Under the county jail's voluntary work program, he and other workers are paid $20 for 10 to 12 hours per day of manual labor at the single stream recycling plant run by the county's Department of Public Works, according to the lawsuit filed a couple years ago. So he's making about $2 or maybe a little bit less an hour. The county also contracted with a temporary staffing agency to place people there who were paid minimum wage and overtime to perform the same work as detainees in the work program. So that's interesting. This man worked at the plant from December of 2019 to March 2020 while serving time for 2 misdemeanor theft and fourth-degree burglary charges. The county suspended the program during COVID. Now, the ruling is the first time the Fourth Circuit has decided whether prisoners who work off-site should be considered employees under that federal statute. The judges did not go so far as to find that this man and the others are covered, but sided with them on several key issues. Using inmate labor at the recycling plant offered a financial boon to the county, which sought to eliminate the use of temporary workers who received minimum wage and replace them with detainees. So the work involved sorting trash from recycling material so the county could sell bales of recyclables to the highest bidders. The detainees' lawsuit claimed conditions at the plant were brutal. The facility became so cold in the winter that some inmates resorted to grabbing discarded clothing off the conveyor belt that carried trash and recyclables, according to court documents. A former shift supervisor testified as part of the lawsuit. They sometimes looked the other way when workers ate food scraps that came down the conveyor belt because he was concerned that the detainees were not being adequately fed. The lawsuit claimed inmates received only one bologna sandwich per shift. And by the way, that's, of course, another problem, is the working conditions. Because there are laws, statutes, codes that address working conditions in the workplace. So if you're working in a plant and it's sub-zero temperatures inside during winter, or it's cooking like you're inside a microwave in the summer, those are also things that are governed by state and federal law. And so if these workers aren't entitled to those protections, it can then become unsafe also. So the judge in the trial court threw out the suit in June, concluding that the work program had some rehabilitative purpose, even if the county saved money by using the cheap labor. The Fourth Circuit panel ordered the judge to revisit the decision and reach a different conclusion. The work program's primary purpose was making money, not offering rehab to detainees. So paying inmates less than minimum wage also gave the county an unfair business advantage, something the FLSA tries to avoid. So one of the reasons the law exists is to make competition in the marketplace fair. The county could pay incarcerated workers less than private employers doing the same work and could afford to offer cheaper recycling services as a result the way things were. The fact that the county also sorted recycling for 2 other counties and was trying to secure business from 4 more only confirms the potential competitive unfairness to private providers. So I remember reading stories about this, and especially down south, where they would tell you, they said, look, you can sit in your cell all day long, or maybe go out in the yard for a little while and talk to Timothy Robbins about your taxes. Or you could go work in a farmer's field someplace. At least you get outside, some fresh air, and we'll pay you. And you get paid, of course, 7 cents an hour. Yeah, by the way, it doesn't add up, because I know you're going to say, but Steve, if these guys are in prison, they need money for the commissary. Oh, yeah, they do. The commissary, where they sell like a $5 radio for $40. Or they sell a 39-cent bag of potato chips for $19, that kind of stuff. So it's difficult. And don't get me wrong, I'm not saying that people in prison deserve every single right that people outside prison have got. I understand that. No, I'm not saying that. Otherwise, they wouldn't be in prison. People outside of prison aren't in prison. But it does seem to me that if the prison population is being viewed as simply a surplus workforce that we can put to work someplace, well, the question is, what are you putting to work doing? And if you got them out there simply breaking rocks in the hot sun, that's one thing. But if you've got them actually doing work that's making somebody money, and they otherwise would be using full price labor someplace else, then I wonder what right you've got to not pay them a minimum wage. So I think I agree with the Court of Appeals in this one, but it's a close call. It's a close call. I'll give you that. So Donald, thanks for sending it. The Baltimore County detainees could be employees who can earn minimum wage according to the appeals court. And like I said, I don't know that there's a distinction between the detainees at the jail and the detainees at the prison as far as the legal thought process goes. So Leah Russell and Madeline O'Neill wrote that for the Baltimore Sun. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Have you ever listened to someone for a while and wondered who ties their shoelaces for them?